Hello everyone, welcome to the NPTEL online certification course titled Medical Law. Myself Dr. Chaitanya Mittal, currently as a medico legal consultant and faculty at Dr. B.C. Roy Multi-Speciality Medical Research Center, IIT Kharagpur. Today we are at the lecture 7 of the week 2, that is the types of consent in medical field. Today we will be discussing only the related to the medical field, how the consent is important. So, coming to the today's lecture, the types of consent in medical field. So, the various concepts to be covered in this is the first, the consent in the medical field. What is the importance of consent in medical field? Introduction part we have gone through in our lecture 6 regarding the consent and some about the importance, but in detail how the consent plays a role in the medical field, medical profession, in each and every procedure, starting from the even vaccination to till the surgery or the life threatening situations. Second, the concept covered will be the various types of consent in the medical field. The detailed information about the informed consent in the medical field or in the various medical procedures. And the last, laws relating to the informed consent. The various keywords involved in it, the consent, types of consent, informed consent, Nuremberg Code, Declaration of Helsinki. So, the coming to the introduction of the consent, that the Oxford Dictionary, how it defines the consent as the permission to do something, especially when given by somebody in authority, or a permission for something to happen or agreement to do something. In classical liberal theory, consent refers to the expression of autonomy and free will by competent and rational individuals who are free from any force, coercion or oppression. So, another definition given under Indian Contract Act, especially the section 13, which defines the consent as consensus ad idem. That means the agreeing the same thing in a same sense. एक ही चीज को एक ही तरीके से करने का मीनिंग है consensus ad idem. The Indian Penal Code also refers to the consent in several places all over the Indian Penal Code 1860. Somewhat we have gone through in our lecture 6. A consent shall be deemed to be valid consent when it is given by person who has attained the age of majority, that is 18 years of age as per the Indian Majority Act, and being allowed to do many things, it gains the age of 18 or gains the age of maturity, that is power to give the vote, to do the marriage, legal marriage within 18 years of age, and the consent to be valid in case of any surgical procedures. Another Indian Medical Council Regulation 2002 also deals with the consent of the patient. The various laws governing the informed consent in medicine in law. The following regulation broadly governing the concept of informed consent in India are Indian Medical Council Professional Conduct Etiquettes Ethics Regulation 2002. Second, Telemedicine Practice Guidelines 2020, in which these also the value of informed consent is very important, being explained in these regulations and the guidelines. Another, the PCPNDT Act, Prohibition of Sex Selection Act 1994. Another, the Medical Termination of Pregnancy Act 1977, which is also an amendment act, Medical Termination of Pregnancy Amendment Act 2021. And the last, New Drugs and the Clinical Trial Rule 2019, in which also explained the value of informed consent given by the volunteers who have participated in the various clinical trials. So, various different types of consent in the medical field. We have gone through in the previous lecture the types of consent, which can be either the informed or expressed and implied. But in medical field there are some new consent also have come up, that is the proxy consent, second surrogate consent, along with the informed consent, express consent, implied consent. So, we will go through one by one. The informed consent. The concept of informed consent has originated in the medical jurisprudence. A consent is an approval or rejection on a subject, particularly after thoughtful understanding and consideration. Informed consent is when the person giving consent is fully aware of all the reasonable and irrational elements of his decision after a piece of information has been provided to him which shall influence his decision. So, the informed consent is very important to take it properly and valid. So, what all the components include in the informed consent to be there to make it valid? Informed consent shall accommodate 4 vital components. The patient shall have the capacity to provide the consent, very important. It should be capable to do so, should not be unconscious, should not be intoxicated, should not be mentally unsound, should be capable, understand the risk involved in, to have a capable to give the proper consent. So, foremost is capacity. Second, should be competent to provide the consent. The competency should be there, should be able to understand, have the knowledge for what purpose he or she is giving the consent. Third, free, voluntarily and informed, to be there mandatory without any force, mistake or any coercion. And the last should be procedure specific. What to be the procedure to be done? For regarding that only the consent should be taken. The proper procedure should be mentioned with the risk involved in that. So, the consent should be procedure specific. So, these are the 4 main components to be there in informed consent to make it valid. Eligibility for informed consent. First and foremost is the age of the patient. Age should be more than or equal to 12 years of age. If person is of age 12 years, can give an consent for doing the medical examination. For any surgical procedures, if the age is more than 18, then he or she can give alone. Otherwise, if in between the age of 12 to 18 is maybe difficult to understand the procedure risk involved it or the benefits of the procedure, it is better to take the consent of parent or guardian along with the patient. Patient consent is very much mandatorily if the age is more than 12. If age is less than 12 or the patient is unsound, the consent of a parent or guardian is sufficient. Second, the capacity to understand the gravity of the risk and the benefit of that particular concern for particular procedure. Third, ability to analyze the information given, ability to deliberate and decide the treatment. So, these are the eligibility or the criteria to be there for informed consent. So, what is the purpose? Purpose of going through the informed consent? To understand nature of any surgical procedure, any medical legal examination of that particular disease or particular patient, or the nature of any research in various clinical trials. So, to understand the nature of the procedure, that can be either the research, clinical trial or any medical legal procedure or surgical procedure. Second, to educate patients about the purpose, risks, benefits and alternative therapies involved in it. Third, to be able to make a voluntary decision about the intent to participate. Last, to provide knowledge about the immediate and future costs. So, these are the necessary to be involved or the purpose of going to take informed consent. So, what is the importance or the significance of informed consent if it is taken very much accurately and valid? The informed consent is taken with the respect to the following: treatment, dissemination of patient information, discussion of health insurance and related laws, specific procedures that can be either the medical procedure or surgical procedure, any surgery which is can be the life threatening, blood transfusions and anesthesia. So, in all respect the informed consent is being taken and they have a very much significance in each and every situations. So, the elements of the informed consent we will discuss one by one. So, first is voluntarism. Voluntarism is defined as the ability of an individual to judge freely, independently and in the absence of coercion what is good, right and best subjected to his or her own situation, values and prior history. It may be affected by factors such as insanity of the individual, which could be influenced by the psychological effects of diseases or disorders, emotional and intellectual capacity of a person to make rational decisions. Third, religious and cultural values and beliefs and the economic status of the individual. So, this includes in a case of voluntarism element, main element of informed consent. Second, information disclosure. The information must be provided to enable the individual to make a rational, informed and logical decision in the light of his psychological, economic, cultural and social beliefs. The information provided must state the health conditions, nature and purpose of the study or the research, the experimental procedures, probable risks and benefits, nature of illness, availability, risk and benefits of alternative treatments and the rights available to the individual. So, this is also a very important element of informed consent, that is the information disclosure. Third, decision making capacity element of informed consent. It is an ability to understand and appreciate the nature and the consequences of health decision and to formulate and communicate decision concerning health care. It is dependent upon the cognitive abilities to able to understand the information, to able to appreciate the situation, to rationalize the information and communicate a choice. So, the coming to the case scenario in Nizam's Institute of Medical Sciences, that is the NIMS versus Prasant S. Dhanaka, AIR 2009 6 SC1. Doctors performed an operation to remove tumor without obtaining consent from the patient, thus held liable for medical negligence done in that procedure, as the medical profession has not obtained a valid consent from the patient regarding the procedure to be done on it. Any act that is done outside of what is consented to will amount to an offence or intrusions of one's autonomy, except in cases of emergency or life threatening situation or done in good faith. So, except in case of any emergency situation, it is mandatory for a medical professional to document a valid consent regarding that particular procedure. If any further procedure to be done, need to be take a new consent regarding that new procedure. Another, Justice Cardozo in case of Shona versus New York Hospital 1914 has held that every human being of adult years and sound mind, adult years means 18 years and above, and sound mind has a right to determine what shall be done with his own body, and a surgeon who operates without his patient's consent commits an assault. So, it is mandatory to take a consent. Secondly, it is autonomy of the patient to do any procedure on him or her. So, it is necessary for the medical professional or a doctor or a treating doctor to take a valid consent from him or her. Next, surrogate consent. This consent is given by family members for minors or adults. According to the Indian Penal Code 1860, children below 12 years of age do not have the legal capacity to give consent. Parents or guardian hold good in law. So, any legally accepted relative or a guardian who is responsible for the custody of that patient whose age is below 12 as a child. So, the parent or a guardian can give a consent on him or her behalf of that child. The Latin phrase in loco parentis refers to a legal term for an adult who is standing on behalf of the parent. In loco parentis is generally used for medical consent in the following situation. The first, to protect the well-being of a minor. Second, where the parents or guardians are not available. So, the loco parentis can be considered. Third, to provide consent for a minor to participate in any research or various clinical trials procedures. Loco parentis can be very helpful in such situations. Next, after the informed consent, surrogate consent, next is a proxy consent. Proxy consent is given by an authorized person before or after death. When the patient is not in the capacity to give informed consent to a therapeutic intervention, doctors are legally bound to obtain consent from a legal guardian or a proxy. The appointment of a proxy decision maker is a legal rather than medical formality. The informed consent cannot be taken in the following cases: when the patient is incapacitated or mentally unsound. Second, life threatening emergencies with inadequate time to obtain consent. Voluntary waived consent. Next, if the patient ability to make decision is questioned or unclear, an evaluation by a psychiatrist to determine competency may be requested. And the last is the minors, that is the age below 12 years of age. In such cases, the informed consent cannot be taken. In a case of a Pravat Kumar Mukherjee versus Ruby General Hospital and others, 2005, CPJ 35 NC, the court held that the treatment shall not be denied and there can be no question of waiting for the consent of the patient or from the person who brought the patient to the hospital. The consent is implicit in such emergency cases. So, in case of emergency situations, there is no need to take a consent. Immediately, the first and foremost duty to save the patient, to save the life of the patient. So, in emergency, there is no need to go through the consent, as the medical professional is saving the life of the patient in a good faith, is doing an act in a good faith. A surgeon who fails to perform an emergency operation must prove that the patient refused to undergo the operation not only at the initial stage, but also after he or she was informed of the dangerous consequences of not undergoing the operation in a written and valid form. In many cases such as emergencies, for example accidents, informed consent cannot be obtained, as there is a lack of time and first and foremost duty to save. So, the Supreme Court has laid down that in such cases the obligation to treat the injured person shall override the procedure formality. That is a specific case of Parmanand Katara versus Union of India and others, 1989, SCR 3997. So, in case of emergency or a road traffic accident or in an unconscious condition, in a good faith, the doctor can immediately go to save the patient, to undergo the treatment without undergoing or taking the informed consent. So, in another scenario, in Vinita Ashok versus Lakshmi Hospital AIR 2001 SC 3914, the Supreme Court held that the doctrine of informed consent requires a doctor to disclose the alternative methods of treatment with benefits and risks. So, coming to the Nuremberg Code, the earliest expression of the informed consent dates back to the 1947 and is found in the Nuremberg Code. It is a 10-point statement delimiting permissible medical experimentation on human subjects, adopted after the case of United States versus Carl Brandon. It states that the human experimentation is justified only if its results benefit to the society and it is carried out in accordance with the basic principles that satisfy moral, ethical and legal concepts. It is adopted immediately after the atrocities committed by the Nazi physicians and the researchers at the end of Second World War 1945. So, lot of mishaps or the wrongs done in the during the Second World War. Because of such atrocities committed during that time, even by the higher authorities, it is necessary to bring the Nuremberg Code, which defines the informed consent to doing any type of any research or the procedure or involvement of any participant, mandatorily to have an informed consent. So, that being documented in the Nuremberg Code. Next, the Declaration of Helsinki. The World Medical Association has developed the Declaration of Helsinki as a statement of ethical principles for medical research involving human subjects, human participants, including research on identifiable human material and data. It was developed in 1964 by the World Medical Association. The declaration is morally binding on physician and its obligation overrides any national or local laws or regulation if the declaration provides for a higher standard of protection of humans than the latter. Berman report, also published in the year 1978, which is also very important in respect of informed consent. This report was created by the National Commission for the Protection of Human Subjects of Biomedical and Behavior Research. This report expanded the definition of informed consent. This report stated that the participants must be kept informed at every stage throughout the experiment. They must be made to understand the risks and the benefits, and the vulnerable groups must be protected. So, the Berman report is based on the following three main principles. The first and the foremost is autonomy, that is the respect for a person. It is necessary if the person or a participant being involved in any research, their autonomy should be respected. They should have taken the proper informed consent explaining the risks and the benefits. So, the first and foremost is autonomy, respect for a person. Second, beneficence. All the benefits involved in that should be told to the person. So, second is beneficence. Third is a justice. So, that justice should be there for particular participant involved in that. So, these are the main principle on which Berman report is based: the respect, beneficence and the justice. Informed consent in India. The Indian Medical Council Regulation 2002 Ethics Regulation governs the duties and the responsibilities of registered medical practitioner and laid down the requirement to obtain informed consent from patient. The Supreme Court in the case of Samira Kohli versus Dr. Prabha Manchanda and another 2008 to SCC 1 has laid down the guiding principles for the purpose of informed consent. So, in another case in Ram Bihari Lal versus Dr. J.N. Srivastav AIR 1985 MP 150, the court observed that if the doctor goes beyond the consent provided by the patient, it is deemed that there is no consent. So, whatever being mentioned in the consent only up to that level the doctor or medical professional has to perform. If anything new has to be done during the procedure, the new consent has to be taken and proceed. Similarly, in the case of Chandra Shukla versus Union of India AIR 1987 ACJ 628, the Supreme Court pointed out that where a surgeon is consulted by a patient and the consent is taken for diagnostic procedure or surgery, such consent cannot be considered as consent to perform therapeutic surgery except only in case of emergency or in life threatening situations. So, coming to the conclusion of our this lecture, the informed consent is a primary document in protecting the rights of the study subject. Procurement of consent forms ensures human dignity and respect for them. It mandates the investigator to maintain high ethical standards. It sets an example for the prospective research participants of high moral grounds and protect them against illicit practice under the umbrella of research or any medical procedures. So, these are the references being used in for this lecture. You can go through it for further studies, the PubMed articles, any medical law international article that is on the informed consent to clinical research in India, a private law remedy, and another informed consent form for surgery in India. So, you can go through these references and the lecture. Thank you everyone to be listening. Thank you.